Did you know 1 in 3 women and 1 in 6 men have experienced sexual harassment in their lives? This is truly a concerning issue, as oftentimes this leads to severe trauma among the victims. My name is Assofat Akmal bin Razali. I am the Exco of Academic and Debate for the 18th UUM Law Student Society. And today, I will talk about your rights against sexual harassment. For now, there is no definitive legislation that governs the issue of sexual harassment. Only recently, the government had conducted the first reading for the Anti-Sexual Harassment Bill 2021. Although this is indeed the step in the right direction, it is still long ways before being applicable in our daily lives. The closest piece of legislation that we have is in the form of the Employment Act 1955. Section 2 of the Employment Act 1955 states that sexual harassment is any unwanted conduct of sexual nature, with whether verbal, non-verbal, visual, gesture or physical, directed at a person which is offensive or humiliating or is a threat to their well-being in the course of their employment. This means that weird and long gazes, dirty jokes, frequent date proposals are some of the light examples of sexual harassments that are usually overlooked at a workplace. If an employee and employer should ever feel that they have been sexually harassed, they can inquire into a complaint. After the complaint is filed, the employer will then have 30 days to investigate the matter. The accused will then have a chance to know who is accusing them and can present evidence to support themselves. For those guilty of sexual harassment, they may be dismissed, downgraded, or be given any other penalties that the employer sees fit. If the complainant is still not satisfied with the investigation, then he or she may file another complaint to the Director General of the Labour Department. The DG may then direct the employer to re-inquire into the complaint. The employer may be liable to a fine of up to 10,000 ringgit if he refuses to do so. However, it should be noted that the Employment Act is only applicable in certain parts of Malaysia and only covers sexual harassments in the private sector. However, recently, our courts have recognized sexual harassment as a tort in the case of Muhammad Rizwan Abdul Razak against Asma Haji Muhammad Noor. In this case, the Federal Court have listed elements for tort of sexual harassment. Number 1, there is a persistent and deliberate cause of unreasonable and oppressive conduct. The conduct was targeted at another person. And thirdly, the conduct was calculated to cause alarm, fear, and distress to the other person. In short, this case had opened the doors for victims of sexual harassment to bring a civil suit against their offenders. Other than that, lodging a police report is also an option, as some forms of sexual harassment constitutes a crime. I sincerely hope that you enjoyed today's episode of Iuris Scientia for the Soul. Till next time, thank you.